welcome back to Politico Live. I'm Vincent Manencourt, tech reporter at Politico. And today we're talking about Britain's third way. That is, can it become a tech hub now that it's freed from the pesky regulations from Brussels? But at what cost to fundamental rights could that be? Here to discuss this with me is Bruno Gencarelli, the European Commission's lead negotiator for the data flows deal with Britain. John Bowman, who was a key negotiator for the UK in the General Data Protection Regulation talks, and Mariano Delisanti, who is a data protection expert at the Open Rights Group, which is a digital rights NGO. Before we begin, let me remind the audience to submit questions via the app and to answer the poll. You can also tweet at hashtag Politico AI. Now, to kick off the discussion, I want to talk about the UK's stated ambition to diverge from EU data protection standards. Now, last week, the UK data minister said that he was willing to sacrifice the data flows deal with the EU, which is the data adequacy decision, in order to make Britain's privacy regime more business-friendly. Bruno, you're the EU's chief negotiator on that deal. It's yet to be finalized, and part of that deal means that Britain needs to stay essentially equivalent to the EU standards on data protection. So what do you make of these latest statements from a UK minister saying that they intend to actually, do their own thing, go their own way on data protection?
Well, first, good afternoon, everybody, and thanks for the invitation. As you know, the UK system as it is today is aligned with the EU system, both the so-called GDPR and the Law Enforcement Directive. That has been a choice of the UK. And those are, by the way, two pieces of legislation that the UK, and I'm sure John will talk about that, contributed to shape and approved and voted in favor when the UK was still in the EU. And that's fully reflected in the UK legislation. But where indeed we have concerns, and we agree with the concerns of the EDPB and the European Data Protection Board and the European Parliament, is the possibility that this level of protection could be lowered in the future, and lowered in a way that would undermine a possible adequacy finding. The process is still ongoing. We're not yet there. And as you know, this is why we have innovated our approach to adequacy. We have introduced a number of tools to address possible future problematic divergence, including, I would just mention one, by limiting our adequacy finding, their validity, by limiting them in time to a so-called sunset clause. So recognizing the current alignment doesn't mean to be unprepared or naive. We have a number of tools that address that possible scenario. And as you've seen, that is a concern widely shared in Europe.
Mm-hmm. Mariano, your group, the Open Rights Group, has been openly very critical of the European Commission's decision to give the UK data adequacy deal, saying that privacy standards are not high enough, and this stated ambition to diverge is worrying. What do you think about Bruno's safeguards, the safeguards that the European Commission has worked into the deal? Are you satisfied with those?
Well, it's okay when it comes to, let's say, Britain's plan for the future UK data protection framework. It's kind of, I understand, let's say, the reluctance of the European Commission to take a strong stance, because at this stage we honestly don't know a lot in practical terms about what they want to do. What we are worried in Open Rights Group, apart from some of the shortcomings that we've been highlighting all along and even before, let's say, Brexit was even a thing, is actually, let's say, where this discussion seems like going. In this regard, I think, for instance, about Oliver Dowen, who wrote a piece in the Telegraph not long ago, outlining a vision where government basically thinks that data is useful, but complying with GDPR is hard. And therefore, in order to enable the use of data, you need to get the GDPR, or you need to lower the data protection standards in order to make it easier to comply with. Now, there are issues, like basically what I want to highlight here is that there are issues with both premises, developments, and conclusion of these arguments. Because when it comes to the premises, let's say, when it comes to, let's say, the GDPR today, it's true, might be a bit difficult to comply with, but this is because we live in an environment which has a very high risk, meaning that whenever, let's say, I can think, for instance, of a case in the Netherlands where we had schools that had to engage in very long talks with Google in order to introduce into safeguards, and after that, still it was found that there are very high critical risk in that. And the problem about that, therefore, is regulatory standards are, of course, important, but if you lower that regulatory standards, what happens is that you're fighting the symptoms, but you're not fighting the cause of the issue, which is exactly the environment around. And when it comes to the development, is exactly, if you want to change that, you need to, let's say, work on enforcement, work on promoting change in data-driven industries. In this regard, there are some initiatives in the UK. However, what I ought to highlight here is that most of these initiatives will rely on government willing to go for it. I'm thinking about the Digital Markets Unit, which is an initiative to bring, let's say, which is an initiative to bring antitrust enforcement in the tech sector. And I'm also thinking about what we've seen with the ICO, which, by the way, has very strong powers. However, it's also, and this is something that was highlighted in the resolution of the European Parliament about that, it is not as independent from government as it should be. And indeed, as we had a government that was trying to promote their regulatory agenda on data protection, and we know they want to promote this agenda, we saw that the Data Protection Authority basically kept a low profile all these years and tried not.
Mariano, just sorry to interrupt, but just kind of keeping you to the core points of surveillance and carve-outs in the UK data protection regime for immigrants, which is, two topics which your group has campaigned hard against, and we've had two court rulings out in the last week, one from the UK, which said that this immigration exemption is illegal, and one from the European Court of Human Rights, which says that the bulk surveillance regime in the UK is unlawful. Do you feel vindicated by these rulings, and what do you think should happen next?
Well, we feel vindicated, but I think that the message that I would like to send here for, the topic of this conversation, which is the UK third way, is exactly that the UK right now is taking a position where they try to look for shortcuts, meaning they try exactly that there is an issue, it needs to be tackled systemically. There is a shortcut, however, you can lower regulatory standards. This is something that eventually brings its bills. We saw it, as you mentioned, last week we had these two judgments, one of the European Courts of Human Rights that ruled about the incompatibility of the bulk surveillance regime of the UK with the Charter of the European Convention of Human Rights. And the Court of Appeal that ruled the illegality of the immigration exemption with the Article 23 of the GDPR. Eventually, this is, let's say, the bill that you have to pay when you try to look for shortcuts when it comes to legal and regulatory environments. A final thing that I would like to add on that is also, let's say, the issue of, let's say, comes instead from something that is more related with digital rights and, generally speaking, the society we want to live. Because when it comes to, we had in the UK, you may have noticed, a situation where the, let's say, A-levels, which are grades that are calculated for students in order to be admitted to the universities, were calculated exactly using artificial intelligence, so it's using an algorithm. There was a huge scandal coming from the fact that this algorithm wasn't as accountable as it should have been. And eventually what you ended up with is with students chanting "fuck the algorithms" in the street, because they were enraged about the decision and enraged about what happened.
Mariano, just to kind of, I just want to bring in Bruno on this point. These two court rulings that came out last week, they obviously will be taken into account by you at the Commission. Didier Reynders, the European Justice Commissioner, this morning said you may have to adapt the UK adequacy decision in light of those rulings. So what's the situation now? Is it back to square one?
No, but maybe let's make a step back. If there are court rulings, they don't come out of the blue. If there are court rulings, it means that individuals have brought action before UK courts, and those courts have acted. This shows that, first of all, the system of check and balance works. This shows, and you know how much this is crucial in an adequacy finding, looking not only at the laws in the book, but also on the ground, in particular when it comes to effective judicial redress, meaning the possibilities for each of us to bring a case before court and have that case resolved. That is something which should be noted and which is very welcome, which shows that the system is functioning. But as Commissioner Reynders said, if I take the immigration exemption issue, we based ourselves on what was the case law of UK courts and the guidance of the Independent Data Protection Authority, the ICO, before this Court of Appeal judgment, and both a UK court and an Independent Data Protection Authority have had concluded that this exemption was in line with the GDPR, because that were decisions that were taken when the UK was still bound by EU law, and the Charter of Fundamental Rights. So it is normal that we take into account how courts and Data Protection Authority interpret the law. I think we give a weight to that, we respect that, and as we would expect others to do with the decision of our own courts or Data Protection Authority. It's true that the interpretation on this specific point has changed, has evolved last week, because the UK Court of Appeal has reversed the judgment of the High Court. This is an evolving situation, a situation which is currently in flux, both as to also the measures. And therefore, we need to assess, and that's what Commissioner Reynders says, we need to assess first the content of this judgment and their possible impact on our adequacy.
Sorry to interrupt. Is it realistic, given the pressure that you are facing, both from MEPs, from data protection authorities, and now this double punch of the two rulings? Is it realistic that you'll be able to finalise that decision before the end of June, which is when the interim deal, which allows data to flow across the channel, ends?
If you let me finish. So it is. That's why we have a decision-making process to discuss and assess the developments, including developments. We are not the master of the calendar, including development that have happened very recently, and indeed, if necessary, amend the decision. This is what is currently being discussed with our member states in so-called, I don't want to use the Brussels jargon or lingo, but in the context of a so-called comitology procedure. And of course, I cannot prejudge of the outcome of that discussion. On the other judgment, which is of course a very important judgment, but let me also say that those two rulings are of a different nature. The other ruling is about, as we know, a system which is no longer into force in the UK, which has significantly been reformed, including on aspects that are the core of the ECHR judgment. And
Okay.
by that, I
and
mean
this is
prioritization.
this
It's
is
an
the
important point. Prioritization by an independent authority, in the case of the UK, a judiciary authority. So there are two issues we need to fully understand and assess, and that's the work which is being carried out right now.
Okay.
It's an ongoing process, and it's a process which is ongoing, if you allow me to say.
Yeah. Thank you, Bruno. And so these two core issues of surveillance and the immigration exemption. John, you've had experience in making regulations in Brussels. You now work at Promontory, advising clients on data protection issues. What kind of things are you telling your clients? Are you worried about this UK adequacy deal now that these two rulings have come out?
Yes, thank you, Vincent. Just to say that I'm speaking in a personal capacity here, but in terms of what businesses are looking for, certainly there is a lot of monitoring of the current situation. I think from an economic point of view, it makes sense for the UK to be conferred with the adequacy status. We understand that there is still a process to go through. Again, not wanting to rely on technical terms, but there isn't really much of an equivalent term in plain English, the comitology process, where effectively the member states get a say in and get consulted on the adequacy decision. I think it's interesting because, I mean, certainly the opinions of the European Data Protection Board and the resolutions of the European Parliament are significant, and those need to be taken into account. But ultimately, the member states, which represent the governments, will look at it in the round and determine whether, on balance, it is best to maintain that free flow of data to the UK from European member states, EU member states, for many different reasons. There may be diplomatic reasons, political reasons, and economic reasons. But I think certainty and stability is something that the business community are hoping for, and they don't necessarily want to have to bear the cost of compliance by putting in, for example, supplementary measures that are in line with the Schrems II judgment, for example, in order to maintain data flows that they've been used to having for a very long period of time. So I think those are the things which need to be borne in mind, and clearly the clock is ticking, as is often said in Brexit terms, at least in the Brexit context, and the end of June deadline is coming up quick. So I think to some extent the Commission, the member states, and also the UK do need to be pragmatic. The judgments, I think, are important, and it may well be that, well, I'm sure that the British government is having a look at the judgment of the England and Wales Court of Appeal and determining whether they appeal it or whether there needs to be some sort of policy modification in order to deal with the issues that were identified by the judges.
I just want to bring in a question from the audience here, since it's on topic. It's from Henrietta Tielemans, and she's asking if there's any indication that member states are changing their position on the UK adequacy decision after the two court rulings that we mentioned. And just a reminder for the audience that the process is that the Commission makes its adequacy finding, and that the member states then have to sign off on the finding, and that they have to do this before the end of June. Otherwise, data will no longer be able to flow between the UK and Europe. Maybe for Bruno and John, do you get a sense of how member states are viewing these latest rulings?
Maybe I'll come in first on this one, Vincent. I have no sense of that whatsoever, but I think the point that is worth raising is that it would be an extraordinary development if member states decided that the UK was not an adequate regime. The UK has implemented the GDPR in law, and and despite the UK having now left the European Union, the UK GDPR is still the law. Now, there are issues which have been raised, of course, about the exemptions in particular, and those were built into the UK's domestic legislation, and certainly the member states will want some assurance and some answers about, you know, whether the rights of EU data subjects are effectively guaranteed if the data is transferred from the EU to the UK. But I think there's a broader point here about adequacy, and there's been 12, I think, adequacy decisions over a long period of time. Is something which is important both to the EU and also to the third countries that the status is conferred upon. But you know, one would wonder whether if the UK didn't meet the essentially equivalent standard as required, then what about all the other third countries that also have this status, and would the same level of rigor need to be applied to the review of those agreements as well? And does that potentially, in the longer term, put the whole system at risk?
Yeah. I mean, perhaps this is a question, because I think that echoes the Commission's line. Perhaps this is a question for Mariano. If the UK can't get an EU data flows deal, then who can? You know, the UK was an EU member. In opposing UK adequacy, are you not then, you know, undermining the whole system of adequacy itself?
Well, our standpoint is different in this regard, meaning that what we care about is basically safeguards and whether these are actually providing for the protections and the, let's say, security that should be providing. We highlight in this regard that when it comes to the United Kingdom, this is an open question in many regards, and we know that in some regards we will need the reform in order to actually meet these standards. The immigration exemption was one example, but also when it comes to the ICO and its accountability against both complainants and the public, we saw that there are issues both with its independence as a regulator and in terms of having a way in the law that allows them basically to close complaints without any meaningful explanation and escape a review from the complainants. These are big issues. Let's say it's not things that you can ignore. And the question for me would be if the European Union actually builds a system that wants to promote data flows based on enforcement of data protection rights, so enforcement of human rights, but later allows a system to be kept adequate, notwithstanding that there is this issue, you know, then the point is what's the issue? What's the whole point about building a system of adequacy then?
Bruno, just on that point of the EU system of adequacy, another headline discussion that you're part of is the discussions with the US to revive the Privacy Shield deal. Can you give us any indication as to when we might get a deal on that? Can we expect it this summer?
Well, I will join the two questions or merge the two questions. You have asked what, and John is probably was very best positioned to answer those questions because he used to represent the UK in that committee. You've asked what the member states are saying, are asking. I'm not here to disclose the content of meetings, but member states want what we want, which is and what I guess both civil society and the business community wants, which is a sustainable, a durable arrangement that is fully in line with the requirements we have to comply. And those two judgments, they concern very important aspects, including if you look at the recent case of the Court of Justice, the exercise of individual rights and their possible exemption or limitation, and surveillance. So it is natural and normal that before taking a decision in one direction or the other on those two draft adequacy decisions, our member states want to understand the implications of those judgments, including on these adequacy findings. The same can be said, although we are talking about very different systems, of the US. This is not a question of whether we will have a deal before the summer, after the summer, at the end of the year, or next year. It's about ensuring that the deal if we conclude the deal, this is a deal that can withstand scrutiny, political scrutiny, legal and judicial scrutiny. And therefore, this needs to be a fully Schrems II compliant deal. And that's what matters here. And that's what matters both for the EU and for the US. It's in the mutual interest of the EU and the US to deliver that stability and legal certainty that stakeholders expect and deserve. If that needs to take some time, it will take some time.
By time, are we talking 2021, 22?
Well, you need, in a negotiation, you have two. You've seen that on the standard contractual clauses and the modernization of the standard contractual clauses, which is something that we do unilaterally, that is in our hands. We said that this was one of our key response to the Schrems II judgment. We had an extremely helpful stakeholder consultation and very useful opinions of the EDPS and the EDPB, and we are delivering on that actually most probably this week. On a negotiation, you need, the expression is that you need two to tango, so that I'm not the one who is fully in control, of course, of that answer. There is a sense of urgency on both sides of the Atlantic. You had Commissioner Reinders this morning. He has issued a joint statement with his counterparts, Secretary Raimondo, which very clear that joint statement expressed that this is a priority for both sides. But we need to have something, as I said, which is sustainable. And that might require time, or we might be very good and efficient and quick on both sides, and we might do this more quickly. But let's not underestimate the complexity of the issues that are at stake. We're talking about government access for national security reasons. We're talking about enforceable rights. We're talking about access to court, and a number of things around that related to the principle of necessity and proportionality. I think that I can only quote Commissioner Reinders. I think he has said many times that this is not a question of a quick fix of a solution that can be found overnight. It is a priority. I can tell you that myself, my colleagues, and this institution are working intensively on this. Okay. Let's see how much time it takes to get to reach a solid solution.
Okay. Just in the last 5 minutes, I wanted to address some of the complaints that have come out from the US and the UK side when negotiating these adequacy decisions, in that they say that the power is very much with Europe. It's a unilateral system, and that perhaps we need to think of a more fleet-footed multilateral system for data flows. And I wonder what the panelists think of the UK, and can it be more fleet-footed than Europe when striking these data flows decisions? It said it wanted to do, I think, 12 decisions a year, given that Europe has managed 12 since 1998 or thereabouts. I wonder what the panelists think of those ideas. Can we have a different system? Is the European system fit for purpose in the coming years?
If maybe I may say something on that. I think that, as always, and I will maybe quote another member of the Commission, Vice President Šefčovič, on these issues, on many of these issues, we need to set aside separate statements, such also the statements you have recalled at the beginning of this roundtable. Statement, ideology, and then realities. The reality of the UK system today, and it's on that basis that we have proposed to find it adequate, and as I said, this is not yet decided, is that when it comes to adequacy, when it comes to international transfers, the UK has the same requirements in its law than we have. And in terms of the requirement for adequacy, the requirements for standard contractual clauses, for BCRs, etc. So our expectation is that the UK, meaning Brexit means Brexit also for data protection, but the UK will, when developing its international instruments, first of all, comply with its own requirements. So that, I think, is an important point to take. And if there would be issue, you have seen the attention of our stakeholders on this issue, our own attention. If there would be questions of so-called onward transfers, that will be part of that those mechanisms of monitoring, of addressing divergence that I have mentioned. The second thing, like, let's try to broaden the horizon. I understand that TRIMS 2 has raised questions, sometimes enthusiasm, sometimes concerns, anxieties, etc. But the true story around the world right now is one of convergence. Those principles, those rights, those obligations that were only a few years ago seen as European or Eurocentric are increasingly global, from Brazil to Japan, from Korea to California or Kenya. And that gives us Europe, but also our partners, more opportunities to strike those deals, to develop those tools that are both protective of privacy and facilitate data flows. You know that we've done with Japan, and this was not a unilateral deal; it was bilateral.
Sure.
We have.
Sorry, just to interrupt. Just to bring John in here, because we only have a minute and a half left. Just as someone who's on the ground in the UK, can you see a world where we have, maybe a different, more multilateral data flow system?
I think I can see that. The data protection isn't fixed in time at any one point, and there is an opportunity now for the UK to kind of carve out a distinctive approach. Bruno's absolutely correct in saying that GDPR is the law, and the third country adequacy process and criteria remain the same, and that's true. I think. But where the UK might have an advantage is being able to actually manage the process quicker and to directly engage with those potential third country candidates. So we've seen with Convention 108 that it's gone from the Council of Europe that there are signatories to that convention which are outside of Europe, in Latin America and Africa and so on. So the UK may well want to focus on those kind of territories to see where they can engage with them on data protection and hopefully encourage the rise in standards as well.
Well, thank you all. That's all we have time for. Please stick around for our next discussion, which is my colleague Nick Vineker, and he's going to be interviewing Microsoft's Casper Klinger in a couple of minutes. Stay tuned. Thank you very much.
Thank you.
Okay.
Your mic is on, Nick, if you want to say hi.
Hello, hello. Not hearing anything, but a hearty good day to you, Casper. Hello.
Hey, how are you, buddy? All good?
Good. Very good. Very
Yeah.
good. Interesting, very interesting exchanges today. A lot of news, including in Denmark. Did you plan this?
I did not, and we shouldn't deal with that topic. I don't represent Denmark anymore.
I'm not gonna bug you about that, but
yeah, no, it is. It's this.